Hello, everyone. My name is Tyler Paitko. I'm in the Labor and Employment group at Husch Blackwell. I'm in the Link, which is our virtual office. That means 99% of my time I work in my man cave. Today, we're in the Oakland office of the firm, and I want to welcome our Labor and Employment team in California. It includes attorneys in our Los Angeles office and also here in Oakland. We've come together today to discuss the latest developments in the ever-changing landscape of California labor and employment law. Before we begin, I just have to make a few housekeeping announcements. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will try to answer all questions during the webcast today. But if a further answer is necessary or we run out of time, we promise we will answer those questions by email after the presentation. Also, there's a PDF of the presentation materials available for you at the program materials folder on your icon. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow along with a recording of the webcast for watching and sharing with your colleagues. Toward the end of the program, be sure to include our short survey. We use your feedback to plan future programs and try to match them to your business needs. That is all for now for the housekeeping items. We're going to get started with the program today. I just wanted to put up the agenda here. Our time is somewhat limited, so we're going to try to stay on track here. We have 3 sections that we're going to be covering today, and please make sure to take a break as needed because we're not going to formally break during the program today. I am very fortunate to be working with a fabulous and dedicated team of labor and employment lawyers. I want to introduce you to 2 of them sitting next to me today to take the first panel, which is the 2023 annual review of labor and employment developments. And that is my colleagues, Allison Scott, and who's to my far right, and Olga Savage, who's sitting next to me. So I'm going to turn it over to Olga and Allison.
Thank you so much, Tyler. Good morning, everyone. Thank you so much for joining us today. My name is Olga Savage, as Tyler mentioned, and Allison and I are going to be covering the key developments in labor and employment law in California that happened this year, and that's going to be the key new pieces of new legislation and as well as some recent meaningful and particularly impactful court decisions. So the legislature has been very busy this year when it comes to labor and employment law, so we're going to jump right in. A couple of the important pieces of legislation Tyler and Zane will actually, our colleagues Tyler and Zane will be covering later in their presentation, but Allison and I are going to talk about a number of pieces of legislation. There's been a number of new laws related to protected time off, new types of leave, and modifications to existing types of leave. We'll cover those. There's been some new legislation on protection of cannabis use, some wage and hour stuff, new legislation on employer obligations to protect employees against workplace violence, some litigation legislation that would be helpful for everyone to know, and a number of pieces of industry-specific legislation that we're going to cover very briefly. So let's go ahead and jump right in, and I will turn it over to Allison to start on the protected time off legislation.
Thank you, Olga. So I'm Allison Scott, and I work in our LA office. So we're going to talk about protected time off for California employees. We saw 2 big pieces of legislation. One was expansion of California paid sick leave, and then one was for reproductive loss leave. So SB 616 is California paid sick leave. It becomes effective January 1st of 2024, and it takes California's paid sick leave and expands the usage, accrual, front loading, and carryover limits. I'm sure everyone's very familiar with California paid sick leave since it's been in effect since about July 1st of 2015. And we've also seen multiple localities implement paid sick leave throughout the state. Now, beginning January 1st of 2024, you're going to see that Usage limits are going to increase to 5 days or 40 hours. Employers are obviously free to give more time off if they choose, but that's the minimum amount required. Again, as a reminder, employees should accrue at least 1 hour for every 30 hours worked. And then the usage limit is what you can put in place to limit how much they use throughout the year. And this alternative accrual that you'll see is something that not many employers have used, but previously you could have an alternative accrual other than the 1 hour for 30 hours worked, so long as by the 120th day, calendar day of the employment, the person had accrued 24 hours. Beginning January 1st of 2024, you have to keep that accrual method, plus you have to ensure that they've received 40 hours by the 200th calendar day of employment. So if you don't want to use the 1 hour for 30 hours worked, you can use alternative accrual so long as you satisfy those requirements. Some employers have chosen to front load paid sick leave, and if you choose to do that, now you need to do front load 5 days or 40 hours. There's also an accrual cap now, and that's increased from 6 days to 48 hours to 10 days to 80 hours. And then also the same as the carryover cap. So it's quite more time off that's permitted for employees who are entitled to paid sick leave. There's also some preemption of some of the local sick leave ordinances. So it's important to take a look to see where the overlap is and see if there's any preemption that might occur if you operate in like LA or Berkeley or San Diego and you have concerns about compliance. We also saw some expansion of paid sick leave for CBA covered employees. So if you have a union that your employees belong to and they have sick leave through their CBA, it's important to note that now the CBA must provide sick leave for the purposes that California paid sick leave has, such as the time off to care for yourself or a family member or for domestic violence purposes. It also includes the requirement that you're not supposed to find coverage and then retaliation provisions. So there's some other additional items there in addition to the expansion of the sick leave. And then the next we have is SB 848, leave for reproductive loss. And that also becomes effective January 1st, 2024. And this is seen as an expansion of bereavement leave. However, this is limited to reproductive loss, and it applies to California employees who have worked for the employer for at least 30 days prior to the leave, and they get 5 days of unpaid leave for a reproductive loss event. And those includes events such as a failed adoption, a failed surrogacy, a miscarriage, a stillbirth, or a failed IVF or IUI type procedure, so reproductive procedure. And it applies to not only the employee who might be experiencing the loss, but it applies to the partner or the person who also would have been a parent. So it's important to consider that when dealing with reproductive loss leave requests, that it doesn't necessarily just apply to one employee or one person in that relationship. It prohibits retaliation for use of this leave. SB 848 is silent as to whether you can request documentation verifying the need for leave. And based upon prior legislation that's been enacted, the silence probably means that you can't request documentation. As we saw with bereavement leave, it's very specific what kind of documentation you can request. The same thing with like domestic violence and sexual assault leave. There's also different parameters for documentation. So employers who are implementing these policies should pay close attention. Another thing to mention too is that the 5 days of unpaid leave must be used within the 3 months of the reproductive loss event, and they can be non-consecutive days. So next we have is cannabis use. And last year we saw AB 2188 be enacted, and it goes in effect of January 1st of 2024. So some reminders: it prohibits discrimination against an applicant or employee for use of cannabis off the job and away from the workplace. This also came with the requirement that employers can't use drug screenings that will detect non-psychoactive cannabis metabolites. And I know I'm not a medical expert, but the bottom line with the drug screening is that we can only be using it to detect whether or not the employee was under the influence of cannabis while on the work site or under the employer's control. So AB 2188 did not apply to employees working in certain fields such as construction or the building trades, or positions that require federal background investigations or security clearances. And it still allowed employers to maintain a workplace that's drug-free and alcohol-free, but it just prohibits the discrimination for any off work, away from the workplace cannabis use. SB 700, though, has been enacted to also limit an employer's ability to request information from an applicant relating to the applicant's prior use of cannabis. So this would include any criminal history inquiries. California already bans lots of criminal history inquiries before a conditional offer of employment has been made, but this is something that you should consider in your application process, especially if you are doing background checks, and this is something that can be disclosed to you. There's additional revisions to the cannabis prohibition. However, it's just mainly to clarify some provisions from last year's new law. I'm going to pass it back over to Olga.
All right. Thank you, Allison. So wage and hour, a couple new developments in legislation on wage and hour, and these are not so much laws that specifically establish certain substantive rights under wage and hour law or change anything about what the law is, more new laws about enforcement of already existing laws that relate to payment of wages and other wage and hour issues. So the first one is SB 497, and so this relates to anti-retaliation laws. So we already have laws in place. California already has laws in place that prohibits employers from retaliating against employees based on certain protected activity, which includes complaining about wage violations, whistleblowing on lawful wage and hour practices, participating in investigations relating to potentially unlawful wage and hour practices, reporting violations of the Equal Pay Act, participating in an investigation regarding a potential Equal Pay Act violation. So that's already been in effect for a long time. It's unlawful to retaliate against an employee based on this type of protected activity. What this new law does, SB 497, it essentially makes it easier for an employee to prove retaliation. So it creates a rebuttable presumption that if an employee was subject to some kind of adverse employment action within 90 days of engaging in the protected activity. So an employee complains about wages, and within 90 days, they're fired, they're disciplined, they receive a negative performance review, they're demoted. It creates a rebuttable presumption that that adverse employment action was retaliatory. So it basically shifts the burden. It's now on the employer's burden to disprove. It's not the employee's burden of proof initially that to show that this was retaliation. It's the employer's burden to disprove that it was retaliation. It's a presumption against the employer. So essentially, if a lawsuit or some kind of action is filed based on that act, it makes it easier for employees to prove their case. The other thing it does is it creates a higher penalty, a higher civil penalty for these types of retaliatory acts. It's now $10,000 per employee per act of retaliation. So definitely an employee-friendly development on a law that's already existed some time. And then the other law that relates to enforcement of wage and hour laws and remedy for wage and hour violations is AB 594, which relates to local enforcement of wage theft. So the idea is that it creates a new mechanism. And by wage theft, wage theft under California law is defined very broadly to include any number of wage violations, not paying employees correctly in different ways, even including acts such as misclassifying a non-exempt hourly employee as salaried exempt. So wage theft is defined very broadly. And what AB 594 basically does, it creates the ability for the local public prosecutor, including the attorney general, to initiate legal action. It could be a criminal action or it could be a civil lawsuit against an employer that is operating within the area over which the DA has jurisdiction for wage theft. So it essentially creates a new mechanism for enforcing laws that already exist. And this is a temporary law. It sunsets and it ends in 2029. But the idea behind it essentially is, for now, recognizing that, for example, the California Labor Commissioner doesn't have the capacity to go after all wage and hour violations, to create a new mechanism for someone else to enforce these laws. Allison, workplace violence?
Thank you, Olga. So we saw a lot of legislation this year, well, 2 pieces of legislation this year on workplace violence. There's 2 points with this. There's going to be workplace violence restraining order updates, and there's also a workplace violence plan that employers are going to need to implement. starting first with SB 428, it updates workplace violence restraining order requirements. So currently, an employer can get a restraining order on behalf of their employees who have suffered unlawful violence or credible threat of violence that can be reasonably carried out in the workplace. There has been or could be. Now, beginning January 1st of 2025, so not this year, but next year, employers can seek a restraining order for an employee who has experienced harassment. And I think that's an important note that we're expanding the definition of why we can obtain these restraining orders, because it's a little bit limited beforehand. The threshold showing was quite difficult sometimes. So now if you have an employee who's experienced harassment in the workplace or from outside of the workplace, but kind of spills into the workplace, you can also get a restraining order for that. Harassment means a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses that person and serves no legitimate purpose. It is important to note that there is a carve out for any speech or activities that's related to NLRA or other employees covered by like a CBA, so public employees. So that is important to note. So if you have somebody that's maybe involved in the union and there's union conduct, that wouldn't necessarily apply there. Next, going to SB 553, this is a workplace violence prevention plan. And this is a little bit more expansive in the fact that it's something that employers are going to need to develop and implement. It requires almost all California employers to develop a workplace violence prevention program that is easily accessible to employees. Employers who are not included are healthcare providers who are already subject to the Cal OSHA standard, employers who have employees that are primarily work remote, or if you have a workplace that's not like accessible to the public and you have less than 10 employees. I think there's also a couple other exclusions, but this will apply to most California employers. And it is something similar to the injury and illness prevention program that California already requires employers to have. And so something you might want to consider developing and revising in connection with that. Employers are going to have to provide training to their employees when they first establish the program. So once we get that all rolled out, we have to do some training, and then thereafter you have to do annual training. So it's something in addition to maybe sexual harassment training, you might need to add on to there. You have to add maintain a violence incident log. So for 5 years, and employees can request to view and a copy of the log. And I believe you have 15 calendar days to respond to those requests. The logs are going to have certain information that you need to include in the workplace violence prevention program, and also needs to be confidential. So you can't necessarily include personal identifying information. And it's going to permit employers and union representatives to obtain workplace violence restraining orders on behalf of employees. That's something that's different, is the union representatives or other representatives were not able to do that before. Some notes though about SB 553, it has a very broad definition of workplace violence, and it can cover a wide array of events. And so when going through and developing your program, it's important that you're going to train your supervisors and managers on the different type of workplace violence that can occur. Some of the definition is subjective, so it could be any threat or physical threat of violence that might not have caused injury, but could have reasonably led to like a stress or like a psychological injury. And so it could really be based upon an employee's subjective belief that they were subject to a workplace violence incident. And so when you're going through and developing your program, it's important to go through that definition and then also train everyone on what that means, so you have you can update your violence incident log and appropriately identify the workplace violence incident. Next, we also have litigation to talk about. This is something that hopefully most of you guys don't end up having to deal with. And when you do, typically we end up handling it for you. But I do think there's some important things to note that's happened for next year. We saw some new legislation further attacking arbitration, which is important for employers who have employee arbitration agreements. California is already very unfriendly with arbitration agreements and enforcing them. Olga's actually going to go over some cases that were decided this last year regarding arbitration. But we saw the legislator eliminate the opportunity to have an automatic stay to appeal a denial of a motion to compel arbitration. And this is important because if you're an employer and you have an arbitration agreement and you have a lawsuit filed against you, you want to file a motion to compel arbitration. Now, if the trial court doesn't think the agreement's enforceable for one reason or another and denies your motion to compel, you don't get an automatic stay. It's up to the trial court now to decide whether or not it should be stayed if you want to appeal that decision. And that means that if you're an employer and your case was not stayed at the trial court, you could be potentially defending your lawsuit while also trying to appeal the decision for arbitration. And so it definitely makes it a little bit more difficult for employers who are trying to use alternative dispute resolution forums. There's going to maybe be some issues with the FAA and preempting this update, but we'll see. Unfortunately, that doesn't mean much for California employers at the moment in time. We also saw some changes in discovery with SB 235, and it actually mirrors a little bit more of the federal rules for discovery, but it has an initial disclosure requirement when a demand has been made. We have 60 days to respond to the demand. And similar to what we already do in federal court, you have to identify witnesses, provide contact information, list or provide a copy of the relevant documents, and then also provide any contractual agreements that would be used to satisfy the judgment. So insurance agreements or any other agreements regarding payment for any judgments that could be issued in the case. Now I'm going to turn it back over to Olga for industry-specific legislation.
Thank you, Allison. So we saw quite a bit of this year, a lot of industry-specific employment laws enacted. We'll touch on these very briefly before we move on to court decisions that impact employers in California this year. So first one is SB 41. It's pertaining to meal and rest breaks for airline cabin crew employees. So it creates situations where airline cabin crew employees can be exempt from California's meal and rest break requirements, but a number of requirements have to be met for the exemption to apply. They need to be covered by a collective bargaining agreement that meets certain requirements. If there's no applicable collective bargaining agreement in place, the employer and the union can agree to a 12-month agreement that meal and rest break rules don't apply while they negotiate the necessary provisions. And this has actually been in effect since March of 2023, but it does recognize the reality that there are practical circumstances where it makes sense for airline cabin crew members to not be subject to California meal and rest break laws, which is helpful. Then we have SB 525, which relates to healthcare minimum wage. So effective June of 2024, it creates specific minimum wage amounts and categories for covered healthcare employees. So what you're going to see is you're going to have a wage schedule that includes increased minimum wages ranging between $18 and $25 for different categories of healthcare providers. And the categories are based on the type of healthcare establishment that they work for, the size and the structure. So obviously, if you're a healthcare establishment, you want to take a look at that carefully to make sure to what extent these new minimum wage rates apply to you, which ones, and to which of your employees. So you'll definitely want to take a look at that carefully. SB 723, this relates to the right to recall in the hospitality industry. So remember, we've already had a law in place saying that employees in the hospitality industry that were laid off due to COVID-related reasons essentially have a right to recall, have a right to first priority, and to be offered a position when a position becomes available. Previously, that right to recall was set to expire in December of 2024. It has now been extended to December of 2025, December 1, 2025. So that law has already existed. It needs to continue to be followed through the end of 2025 at least. Next, we have AB 647, which essentially expands and creates a modification to the already existing law about successor liability for grocery employers. So we already have a law in place saying that when you've got a grocery employer who is a successor to another employer, they have to offer an opportunity to remain in their position to employees who have worked for the prior employer when a change in control like that takes place, and they have to give them an opportunity, they have to give them preferential hiring options and to make positions available to them before making those positions available to the general public. AB 647 expands that law in a couple of different ways. First of all, it expands the definition of what is a grocery establishment to include distribution centers. So distribution centers now need to comply with that law. It also creates creates a new private right of action where employees can actually go in and go into court and enforce their rights under this law and just sue for violations of this law. So already existing law and some expansion to it that requires attention. AB 1228, which is the fast food industry related legislation. So this is a little bit confusing. So there was a law that previously was created, the idea of it being that there would be a new fast food council created within the Department of Industrial Relations, and that fast food council would have incredibly broad authority to set rules and requirements regarding various work conditions in the fast food industry. It had really, really, really broad authority under the original law that was enacted a year ago. However, that legislation was suspended pursuant to a referendum petition. So then there was this negotiation, and under the negotiation, a new rule an agreement was reached where under AB 1228, if the referendum is withdrawn by January 1st of 2024, the original legislation that established this fast food council with broad authority is going to be repealed, and a new fast food council is going to be created that has significantly more limited power and authority. So stay tuned on that one to see what happens next year in January. And then the last one of these industry-specific rules is SB 476, which relates to food handler licenses. And so it essentially requires employers to compensate employees as hours worked for the time they spend having to train and take the examination to obtain the food handler card, and also gives them a right to take time off and do what is necessary to obtain this mandatory licensure. So that's a very quick summary of these industry-specific laws. Let's move on now to legislation, because to court decisions, because the courts have been busy as well, and we'll touch on kind of the key pieces here. We're going to talk about the latest in court decisions on arbitration, some of the outcomes of litigation we had going on in the aftermath of COVID and various COVID-related issues, and then other recent decisions that we all want to be aware of. So let's start with arbitration real quick. So as a very kind of quick and dirty summary on arbitration this year, we've got good news, we've got bad news, and we've got good news that makes the bad news slightly less bad. That's probably the best way to describe it. So let's start with the good news first. So this is a decision that we had come down in the Ninth Circuit Court of Appeal this year in the case of Chamber of Commerce versus Bonta. And this should probably sound familiar to everyone because we've been on this emotional roller coaster since about 2019 at this point, when the California legislature enacted AB 51, which said that employers cannot require mandatory arbitration agreements as a condition of employment. And in fact, doing so is a crime, which was obviously a huge shock to everyone. We've all understood for many, many years and probably decades that it is okay to require arbitration as a condition of employment. So then we went through this whole painful process where, of course, the law was immediately challenged. In 2020, a district court said, no, you can't have this law. It's preempted by the FAA, and it enjoined California from enforcing it. So wonderful, good news that in 2021, the Ninth Circuit reverses the decision and lifts the injunction. Bad news, the law is now enforceable. 2022, the Ninth Circuit says, okay, we're going to take a second look at this, grants rehearing on this issue, fingers crossed. And finally, in February of this year, the Ninth Circuit says, no, you can't have this law, California. The Federal Arbitration Act, the FAA, preempts AB 51. AB 51 discriminates against arbitration agreements. It essentially treats arbitration agreements less favorable than any other contract out there. It creates a deterrent effect that's antithetical to the liberal policy favoring arbitration. So no, you can't have this law, California, you cannot enforce it. So this is good news, right? This is a victory for California employers who want to implement mandatory arbitration agreements. Right now, it's okay, you can do it. The time period to seek review of this decision to the California Supreme Court has passed, which is good news. Who knows, there might be more challenges on this issue in the future, but at least for the time being, we are in good shape on mandatory arbitration agreements for your employees. You can have a mandatory arbitration program. So let's talk about the slightly less good news. And this relates to the issue of arbitration of PAGA claims. We all know about PAGA, the very popular claim, the bounty hunters law, which allows employees to sue for penalties, quote unquote, on behalf of the government, on behalf of themselves, and any other aggrieved employees. So as you probably recall, for many, many years, California said that because of the important public policy principles behind PAGA, you cannot have an arbitration agreement saying that PAGA, either waiving PAGA claims or saying that PAGA claims have to be pursued in arbitration. In fact, we had decisions that even went as far as saying if you have an unenforceable PAGA language requiring PAGA arbitration or waiving PAGA in an arbitration agreement, the whole arbitration agreement could be found unenforceable. So we've been so careful, explicitly carving out PAGA claims in arbitration agreements. And then we had some really good news in 2022, where the United States Supreme Court in the Viking River case said, no, an employee's individual PAGA claims can be compelled to arbitration. So remember, there's two types of PAGA claims. There's the claim for PAGA penalties that an employee is pursuing on behalf of himself or herself, and then separately there's the representative PAGA claims, the claims for PAGA penalties that the employee is pursuing on behalf of other what's called aggrieved employees, other employees who were subject to a violation. So Viking River says, no, you can compel arbitration of individual PAGA claims, and better yet, if an employee's individual PAGA claims are compelled to arbitration, that employee loses standing to pursue the representative PAGA claims on behalf of the other employees, and those claims get dismissed. So obviously, wonderful, everyone was very happy, individual PAGA claims go to arbitration, the representative PAGA claims get dismissed, fantastic news for employers. Well, not surprisingly, the California Supreme Court did not like that. So in Adolph versus Uber Technologies, which came down this year, the California Supreme Court disagreed with the United States Supreme Court on Viking River on the dismissal of the representative PAGA claims. So it's still permissible to compel, under this new decision in Adolph, it's still permissible to compel an employee to go to arbitration on his individual PAGA claims, but the representative PAGA claims don't get dismissed. So you go to arbitration on your individual PAGA claims, but you still have the right to pursue the representative PAGA claims in court, which is, of course, really disappointing because that was a part of Viking River that everyone was so excited about. So now basically an employee can do both, arbitrate his individual claims, go to court on the representative claims. Now, which is disappointing, of course, but the good news is the Adolph court did say, all right, well, the outcome of the arbitration will determine whether plaintiff has standing to pursue the representative PAGA claims in the first place, right? Because if in the arbitration, the arbitrator finds, well, nothing bad happened to the employee, so the employee is not aggrieved, then that employee has no standing to go to pursue the representative claims. So in light of that fact, what the Adolph court suggested is the court action with the representative PAGA claims should be stayed pending the arbitration, which is good news, right? Because then you can stay the court action, you can focus on trying to win the case in arbitration, and if you win the case in arbitration, then the court case goes away. So that is good news, that there's some silver lining in what's otherwise a very disappointing decision, and it creates some practical tips for employers to follow. Certainly, employers should include PAGA claims as part of the claims subject to arbitration in the arbitration agreements, but what you want to be very careful not to do is not to include a wholesale waiver of PAGA claims. Right? You can have the class action waiver. You can't have a wholesale waiver of PAGA claims because under Adolph, employees still have the right to pursue those claims in court. It's just that there's reasoning that the rationale is that they should be temporarily stayed pending the arbitration. Given this decision, it's probably a good idea for employees to include a provision in the arbitration agreement specifically requiring a stay of those representative PAGA claims pending arbitration, because it'll make it easier for the employee to argue for that if that issue is ever disputed. And employers really should always include a severability clause to account for any future changes in the law, a clause that basically says, hey, if the law ever changes or if any portion of this provision or this agreement is found unenforceable, the court should just enforce the part of it that is enforceable. Most employers do that already. It's just as it's equally important for them to continue to do that now. So that's arbitration. Allison, what about litigation in the aftermath of COVID?
Yes. Thank you. So we saw two cases that unfortunately did not provide any real grace to California employers who are responding to obviously a very urgent situation when the COVID pandemic hit. And so we'll go through those for you, but overview is that vacation payout for furloughed employees did result in some liability for the employer, and the same thing for expense reimbursement. Starting first with Harstein v. Hyatt Corporation, they furloughed about 7,000 employees due to COVID pandemic. and there was not a concrete return to work date. As everyone probably remembers, back in March 2020, things were shutting down very quickly and no one knew how long it would be. I know I personally thought when I went to work from home, it'd be all of 2 weeks, and months later, I was still working from home. However, here, the employer did not pay out accrued vacation when they furloughed their employees. They argued that there was not a termination because they were furloughed, because they had to shut down their operations. So there was not a complete severance of the employer or employee relationship. Now, I'm sure most of you know, in California, vacation is considered wages, so it must be paid at the time of termination. And here, the Ninth Circuit Court of Appeal decided that the layoff without a specific return to work date within a normal pay period constituted a discharge. So it meant that the employer had to pay out the vacation as final wages once they furloughed those employees. So that's a really important decision because there was no grace given to them for the really uncertain times that we were experiencing. The court took a very harsh line on that. It's also important to note that's maybe not in this decision, but because of the failure to pay the wages, the vacation time at the time of termination, there's also waiting time penalties that the employer is likely going to have to owe to all those employees based upon this decision, unfortunately, which can be very expensive. The next one is the TIE v. International Business Machines, IBM Corp. It's also another COVID decision. And here, the employee alleged that they were not reimbursed for business expenses. So for equipment that they use at their home, such as the internet, telephone, headset, computer, accessories, other things like that, in order to continue to work from home for the COVID stay-at-home orders. Here, IBM argued that because the COVID orders mandated that their business shut down and employees work from home, that they were not the cause of these expenses that were incurred, and so they were not liable for them. Unfortunately, the court disagreed and said that the expenses incurred to work from home, even as a result of those COVID stay-at-home orders, was a necessary expense for the employer. And for those of you who might not be aware, California does require employers to reimburse employees for all business expenses incurred related to the employment. So those would be things such as using your internet at home, using a cell phone for work purposes, traveling, other equipment that is necessary. So I know, again, no grace was granted to this employer for the COVID uncertainty that happened, and obviously a situation that was ever changing. But it's important to remember that California is going to very much stick to enforcing the California Labor Code, even in those urgent situations. So not very helpful, maybe necessarily going forward, but something that's good to reflect upon for any future situations that might come up that are urgent. Now, passing it back to Olga for some other recent decisions.
Which I will describe in exactly 49 seconds. So just a couple of very quick notes on a couple of other decisions. In Rains versus U.S. HealthWorks, a job applicant sued a third-party medical provider, alleging that the pre-hire health screening questions violated FIA. The third party said, hey, listen, I'm not the employer. I'm just the agent of the employer running the background check. I can't be sued directly for discrimination under the Fair Employment and Housing Act. The court disagreed. A provider, an agent of the employer who carries out FIA-regulated activities on behalf of the employer can be directly liable if those activities are discriminatory and violate FIA. And then finally, we had this Woodworth v. Loma Linda decision that gave us bad rulings both on rounding, which we already had in camp before. Facially neutral rounding policies on wages are unlawful. Also, PAGA manageability is not a basis for striking a PAGA claim. Now, the good news is the Supreme Court is going to weigh in on PAGA, but who knows? We don't know what the decision there will be, but not a great outcome for the employers. With that, thank you so much for your time. I'm going to turn it back over to Tyler.
Wow, that was a whirlwind. Thank you, Olga and Allison. As somebody who lives and breathes California labor and employment law, I've learned a lot just in the last 35 minutes. I hope that the audience did as well. Just to give you a little preview, we put up a poll question there. And the idea is we'd like the audience to rank those topics. What do you want to hear about? Because the last session after the next section on protecting employer assets, we will take those questions in terms of the ranking and try to address the questions from the audience as part of our roundtable. So next up on the agenda here is the panel on protecting employer assets. I want to introduce my colleague Zain Zubair, who is in the Los Angeles office of the firm, also specializes in labor and employment law. And just so you have a little preview, the last section, our last colleague, Mike Mata, would join Olga and I to talk about those poll questions, what you rank and what's important, and try to address all the questions in the roundtable. Whoops, I am. Okay, so here is the agenda here for this panel. And, we're going to first talk about just the broad topic of protecting employer assets. Obviously, it's become a lot more challenging today in light of the pandemic and the trend towards more and more remote work. I use the analogy of the horse out of the barn, the toothpaste out of the tube. How do you get it back in once it's gone? So that's a real problem for employers, not only in California, but nationally and internationally, with more and more remote work. The second topic we're going to talk about is some new California laws that govern restrictive covenants. We think about covenants not to compete, the traditional post-employment non-compete, and then also some selected federal and non-California developments. And you'll see that, as you probably heard, the trend is to ban most post-employment non-competes. It used to be just California, but that's spread. We're also, the last topic is current trends and best practices on protecting employer assets, property interests, trade secrets, other confidential proprietary information. Just in the interest of time, we included a lot of slides there for kind of practical tips. We probably won't get through all of those slides, but we wanted to give you some bonus slides so you can read them at your leisure after the program. And then if there's time, obviously we want to answer questions in this evolving area. So a little bit of background here. California, as many of you know, has been on the forefront of banning most post-employment restrictive covenants. California has banned non-competes, for example, since 1872. It's kind of famous or infamous depending on your perspective. And it's interesting because it's in the California Business and Professions Code. We heard a lot from Olga and Allison about the labor code. This is in a separate code section, and essentially that bans any restraint, any contractual restraint on the exercise of a lawful trade or profession. That's the law that's been on the books. It was actually originally in the civil code, not to digress too much, but now it's in the Business and Professions Code. Well established in California. And, we hear a lot, even from my colleagues that are on the management side, California versus everyone. And I'm here to say this law has benefited Californians and the California economy. We're now the 5th largest GDP in the world, just California alone. And as I said to my colleagues, in the immortal words of Scott Stevens, the defenseman for the New Jersey Devils, hey, Japan, you're next. They're number 4. California's going to pass Japan within a year. So you can see how that has benefited the economy, Silicon Valley. A little bit of history. In 2017, California passed Labor Code Section 925. It bans non-California choice of law and non-California exclusive venue provisions in employment contracts. So that means in the old days, employer would try to skirt the law and say, I'm going to select New York law, Minnesota law, and no longer under 925. If the employee primarily lives and works in California, they're not going to be subject to a non-California choice of law or venue. And 925 also authorizes injunctive relief, attorney's fees to void those provisions in court. We also have in the Business and Professions Code, again, 17200, prescribes any unlawful, fraudulent, or unfair business act or practice. Very broad statute. And it's used in consumer cases, but also in employment law. It actually is the reason why in these wage hour putative class actions, the employee, the class is allowed to go 4 years because it's considered a form of unfair competition. Paying less than is legally required gives you an unfair competitive advantage. In addition to those statutes, we've also had case law that's evolved over time. So Edwards versus Arthur Anderson, California Supreme Court said that non-solicitation of customers provisions are also unlawful. They violate 16600. That's also another contractual restraint. The Supreme Court rejected the Ninth Circuit's narrow restraint gloss on 16600. So the Supreme Court said if the legislature wants to change the law and allow for limited exceptions, they can do that. We're not going to do it by judicial fiat. And then more recently in 2018, we had A&M Healthcare versus Aya, and that was a Court of Appeal decision out of San Diego that banned most post-employment non-solicitation of employees provisions. So when we talk about non-competes, that also may include non-solicitation provisions, customers and employees, because that is a restraint. It does affect employee mobility, which is what 16600 is designed to protect. So I want to introduce the new law that we're going to see January 1, 2024. And again, it's just a continuation of this trend. It requires, the most important thing is it requires employers to notify all current and former employees by Valentine's Day. So it's a good way to remember. We're getting a Valentine's Day present from the legislature that they signed a non-compete provision that is void and unenforceable. And that it applies to employees that are employed after January 1, 2022. And the notification, as Zane will describe, has to be in writing. And we're advising employers to get that out before the last day. So not on Valentine's Day, but do it ahead of time. Prudent employers will do that and stay ahead of any violations here. But turn that over to Zane.
Thank you, Tyler. Hi, everyone. I'm Zane. I'm an associate in the LA office. And yeah, so as Tyler was just describing, as part of the new law, beginning effective in the new year, California is further restricting the use of post-employment non-competes by also now authorizing lawsuits against employers who include or seek to enforce void non-competes. And so previously, many courts would find that there was no private right of action. That has now been codified into the new law. And part of the reasoning that the legislature found in issuing the new law was that they determined, or they found that a lot of California employers are continuing to include these non-compete clauses, and ultimately that has a chilling effect on mobility and employees seeking other opportunities.
Yeah, this kind of follows some case law in California, which held that the average lay employee is not going to hire a lawyer to review their employment agreement on whether the non-compete is enforceable or not. As the court said, it's not me, the court said the average lay employee is just going to assume that's enforceable. If the employer included it, it must be enforceable. A lot of employers still think, well, we'll include it as a deterrent, but if we're challenged on it, we'll retreat and say, oh, no, this is California. We don't need to enforce it here. And increasingly, the courts in California and now the legislature said that's not okay. It's a deterrent, and it chills competition, it chills mobility, it suppresses wage rates, on and on and on. It hurts the economy. It's anti-competitive.
Right. And in addition to that, legislature also found that, with the current trend towards remote work and recruitment efforts of companies from all over the country looking to hire talent, they also found that out-of-state employers are also continuing to include and seek to enforce the non-competes. And the new law that's been codified is the Business and Professions Code 16600.5. And so employers are, prohibited from entering into a contract with an employee or a prospective employee that includes a void non-compete. And if an employer does indeed enter into a contract that is void under the new law, or seeks to enforce a contract that is void under the new law, they'll be now committing a civil violation. And so, as we talked about, the private right of action has been codified, but on top of that, there's also remedies that are now codified into the new law. So the employee, if they were to prevail, and it's either a current employee, a former employee, or even a prospective employee, they can now seek injunctive relief, actual damages, and even be awarded reasonable attorney's fees and costs on top of that. And so the new law is expanding potential liability for merely including and seeking to enforce non-competes and non-solicitation provisions. And it's also precluding employers outside of California from enforcing non-compete provisions for employees who work in California. I think this raises a lot of questions as far as choice of law, constitutionality, that I think we'll have to continue to monitor as it goes. And it kind of goes without saying, we'll anticipate more litigation under this new provision challenging non-competes. And unfortunately, it just kind of adds another weapon to plaintiffs' attorneys in the toolbox. So we'll be following those.
Yeah, I would just add that with the attorney's fees potential, there's an incentive to bring those actions. And if you think about it, if it's a former employee who's leaving to go work for the competition, and you include one of these non-competes, you've just given them leverage and ammunition, and they may feel like emboldened, because they're going to be challenging that agreement that was not drawn in conformity with California law.
And so to kind of quickly summarize, what does this ultimately mean for employers? So before the new year, California employers should really, thoroughly review their employment agreements, offer letters, handbooks, policies, and really delete all void non-competes and non-solicitation restraints. And then, like Tyler was also mentioning earlier, before Valentine's Day, it would be prudent for all California employers to actually mandatory to notify in writing current and former employees that any non-competes that they signed are actually void and enforceable. It doesn't actually define what a non-compete is, but likely it will include non-solicitation of customers and employees provisions as well.
Yeah, and we view this as an opportunity for California employers to really clean up the books. And if you, and they mentioned it, offer letters, proprietary information agreements, NDAs, employee handbooks, any contract, really scrutinize those, because you want to eliminate, and this is a perfect opportunity. You can sell it to the employers as there's a new law going into effect, and we're revising our agreements, make sure that they're enforceable. And while you're at it, there's probably some other things you can include, like exit interview requirements and how to get your data back when employees are leaving, especially if they're working in Montana and you want to get your trade secrets back to the company when somebody departs. Okay, so in addition, this is not just a California issue as a point of this. We also have two major federal agencies. The FTC, Federal Trade Commission, it's actually a consumer protection agency, but it has now proposed a rule banning most non-competes, post-employment non-competes. And you'll see that in just January of this year, 2023, FTC issued its notice of rulemaking. They've received a ton of public comment. I was just at a program in Seattle. We had a member of the FTC commenting about this. It's still in the works, and you can still get public comments into the commission. But with that new law, the FTC also started filing lawsuits against individuals for unlawful, what they perceive to be unlawful non-compete restrictions, and they view it as a anti-competitive. And that's why the FTC is weighing in. The FTC proposed rule, and again, this is not a rule yet, prohibits employers from entering into a non-compete with a worker, and it applies retroactively to non-competes the company has entered into already. it defines a non-compete clause, non-complete, but non-compete clause as a contractual term between an employer and a worker that prevents the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. So that's very broad language. That may also include non-solicitation provisions because the FTC is likely to say those are similarly anti-competitive. In addition to the FTC, the NLRB, the Biden Labor Board, National Labor Relations Board, has become very pro-labor union and has had a pro-labor union agenda. The general counsel of the NLRB, Jennifer Abruzzo, issued a memorandum in 2023 opining that most non-complete agreements violate the NLRA. And again, the NLRA regulates non-supervisors, so rank and file employees. And that's where they're more challenging with the rank and file employees as opposed to executives of the company. This was a few months after the FTC rule came in. General Counsel of the NLRB issued its memorandum that non-compete provisions violate the NLRA except for limited circumstances. The theory of the NLRB, there's Section 7 in the NLRA, which protects concerted activities by employees to complain about their work conditions, to badmouth their boss, badmouth the company. That's all protected under the NLRA. And in the board's view, both the non-compete restrictions, confidentiality restrictions, non-disparagement provisions also violate the NLRA and violate this Section 7 right to complain about the working conditions. In addition, and this isn't necessarily a protection of employer assets, but it's just part of the trend to crack down on confidentiality. So this is a federal law, the Speak Out Act prohibits preemptive non-disclosure and non-disparagement clauses in matters involving sexual assault or sexual harassment. So this was passed at the end of 2022. Employers are still understanding what it means. What it basically means for serial harassers, you no longer can get a broad confidentiality. The Weinsteins and all the other bad actors will be exposed. And as the name indicates, the Speak Out Act is designed to avoid keeping that in the closet.
I think we'll move on just for the purpose of time to next main topic. As far as, protecting employer assets, misappropriation, more generally, obviously protecting trade secrets, confidential information has always been challenging as it is. But we do just want to point out with the recent trend of remote work, bring your own device policies to work and practices, that's kind of just exponentially increasing the risks and challenges. And so we really just want to remind employers that they should really hyper-focus on more preventative policies and practices, and also make sure they're realistic and enforceable. And some examples I think we touched on a little earlier were reviewing and carefully drafting exit interview policies, looking at the PIIAs, thoroughly reviewing handbooks, offer letters, contract provisions. And some things that you can do are, requiring prompt return of employers' trade secrets or confidential information, or the permanent destruction of that information. Some recent practices that we've been seeing implemented also include remote wiping of employer data from terminated employees from personal devices, and making sure that you have the policies to permit that.
So, in California, since we've been working with this non-compete ban for quite a long time, the workaround for California employers is trade secrets. So your trade secrets can include information about your customers, and that can be off limits. And the advantage of trade secret protection, if done correctly and drafted correctly, it has an indefinite shelf life. So as long as the information has economic value and is kept secret, reasonable steps to keep that secret, it could last forever, as opposed to a more limited, temporally non-solicitation provision or a non-compete in some states that will allow them. You're limited to 1 year or 6 months or maybe 2 years max. So if it's done correctly, and we believe the trade secret protection can actually be broader than a covenant in an employment contract. So that's the workaround.
Right.
And that's what the next slide shows. So it's a trade secret derives value from not being generally known. And it's a requirement that you also take reasonable steps to keep that secret. The case law says that employers are not required to build a, quote, impenetrable fortress, but having reasonable measures in place like NDAs, return of property when you leave, exit interview policy, all of those things go to the secrecy element, that you took reasonable steps to get your stuff back. And as Zane mentioned, the real challenge here, especially post-pandemic, is the trade secrets are out there in the world. Employees are working in Europe, in Asia, in Hawaii, and if you have a rogue employee or maybe a rogue competitor, there's just a lot more risk that your stuff is going to get leaked or stolen. So that is the challenges that we're facing now.
Yeah, and some additional challenges also include potential overtime liability. We're really now having to trust employees where they are and what they're accurately recording as far as time worked, etc. And with these bring your own device to work policies, now employees can decide to connect their own technology, or even worse, have a former employer's technology inserted into a current employer's network without even, the current employer even knowing or acknowledging. So inadvertently, an employer can find themselves in really expensive and unwanted misappropriation litigation. And on top of that, thousands of dollars of forensic costs to permanently remove any non-company data from your network. A pretty good example as far as a case for this is the Waymo versus Uber litigation that's since settled. And if you're, either in Silicon Valley or the tech industry, or just monitoring trade secret litigation, you've probably come across this at some point. But this involved a employee, Mr. Lewandowski, who was, I believe, an engineer at Waymo. It's a subsidiary of Google, and he's working on like the autonomous vehicle space. He abruptly quit from Waymo at some point, and then he started his own company, and then Uber ended up buying the company, and then Waymo alleged that Lewandowski and Uber were essentially in cahoots. He downloaded allegedly thousands of confidential data and information. And in the case, Uber contended, that Lewandowski had downloaded this data without Uber's knowledge at all, without their permission or consent. But even then, the district judge, Alsup, he issued a preliminary injunction that required Uber to quarantine and not use Waymo's data that was allegedly stolen. And I think it settled for somewhere around like $245 million. So
I guess we can say it's no longer alleged.
Yeah,
at that point.
Very true.
So, I mean, Zane makes a good point. The practicalities of this, if the employer does it right, you want to dispel any reasonable expectation of privacy by the employee on their personal devices, on their iPad, whatever they're using for work, even USBs, have a mechanism to get that stuff back in the handbook, in the offer letter, in the PIIA, Proprietary Information Invention Assignment Agreement. And the key is that employees, you can lawfully say, do not have a reasonable expectation of privacy when using the company network, the company systems, the company computers, even the phones that are subsidized or paid by the company. So it's a matter of making it clear in a policy that employees do not have a reasonable expectation of privacy there. And I mean, I'm a little bit surprised by the case law in this. You know, there was even a case, I think it's on here, it's the Holmes versus Petrovich case, where the employer was able to get the plaintiff employees private conversations. I say private, it was on the company network, and it was conversations with the employee's lawyer. So you'd think that's kind of the sacred privilege, you can't get that. Well, the court said no, you know, with a proper policy in place, the communications are akin to consulting his lawyer in the employer's conference room in a loud voice with a door open, so that any reasonable person would expect that their discussion of their complaints about an employer would be overheard by him. That's an older case, 2011, but it still applies today. So you have the policy, employee might think, oh, I'm just gonna go on my Gmail, but I'm sending it from a company laptop. That's not private. You know, that's, employer has access to that. They can get access to all communications, whether you're starting a new business, as I found in one case, or you're planning a lawsuit, or you're trying to steal other coworkers, that all can be monitored by the employer lawfully. So again, in your, especially with the BYOD, bring your own device to work policy, you want to make clear that the employees have no reasonable expectation of privacy in those messages. The employer reserves the right to monitor that and to inspect that, just like you would in the old days, a company locker or a desk. You have a reasonable, employer has a right to inspect that to make sure there's no theft or any other wrongdoing. We're not going to cover all of this material. There's obviously with more and more remote work, increased risk of data and security breaches. Most states now have a notification statute, requires notification of any data breach. You've heard it probably most in the financial services industry, but it applies to all employers where there's a data breach. I know in California, there's a law that requires a timely notice to any affected employee or consumer. It's important to audit employers' security protocols now, more important than ever with the rise in remote work. Olga and Allison mentioned business expense reimbursements. There's a case, Cochran versus Schwann Home Services, basically says an employer has to reimburse a prorated share of the employee's cell phone expenses if it's used for work calls, even a personal cell phone. So I think you know, we're going to see more litigation on expense reimbursements. We've already seen an uptick, more putative class actions saying that, you know, I didn't get reimbursed for my modem, my printer, my internet access, my phone. So you know, that's a word to the wise, employers out there. Olga and Allison mentioned this PI case. So that's another example. Even though the employer had a government order, stay at home, they were still liable for necessary business expenses for employees working remotely, even though it was compelled by the pandemic and by the governor's stay-at-home orders and county stay-at-home orders. I'll just mention one other thing in terms of protecting assets. The litigation holds are increasingly important to preserve all evidence. The second bullet point there, you know, what is an employee to do? You get a lawsuit or a demand letter. How do you put a hold on text messages, personal electronic devices, other data that might be at an employee's home, but that might be relevant to the litigation? It's a real challenge for employers to cabin that, to make sure it's preserved, because you don't want to get to trial and get a adverse inference instruction, jury instruction, that the jury is allowed to assume that the evidence that was allowed to be deleted is necessarily adverse to the employer. You don't want to adverse inference jury instruction. The same things in litigation, you're going to get subpoenas for cell phones, record for text messages. There's questions about how long the providers retain that information. So that's something for the litigators out there that is a real challenge for employers. I'm not going to go through all the slides here, but in the slides, there's a bunch of practical tips for designing bring your own device to work policies, elements of the policy, and tips for employers to make sure you're protecting your assets. I would say the number one thing is you have an opportunity to clean up your policies, your offer letters, your PIIAs, your handbooks. And now is really the time to do it. With the change in the law, it gives a convenient reason for employers to clean those up. Okay, I just put up the last slide there. You have the slides, and if you have questions, anyone about the material, please feel to reach out to any of us. I included Zane in my email on there, and we both love this stuff, this area of law. So reach out, and hopefully we can help you with your protecting employer asset questions. With that, we're going to transition now to our roundtable. And I don't know how the questions came out in the rankings, but I'm gonna let Mike Mata is another one of our colleagues I introduced earlier, joining us now, and he's going to moderate our roundtable. So I'll hand it over.
Hey everyone, my name is Mike Mata. I'm in the Los Angeles office, also live in Florida County. I'll be moderating the poll questions today for us. Looks like we've done a few hits, so thanks everyone for answering the questions and identifying some topics to discuss. First, the biggest hit that we got was about managing accommodation requests and in the interactive process, specifically common mistakes that we've seen made by employers. So this is, I'll go ahead and jump in and talk about some mistakes that I've seen and kind of some practice tips. I think one of the big ones that I've seen is employers forgetting that the duty is ongoing. So, for instance, an employer will learn that an employee has a disability. They'll, take the proper steps to identify an accommodation for them, but then stop interacting with the employee and kind of not really follow up with the employee to identify whether the accommodation is still useful, whether there are changes to the accommodation that might be necessary. And again, California law makes it very clear that the duty is ongoing. So be sure to regularly check in to see how the employee is doing and make sure, of course, that you're complying with the existing restrictions that they might have. That's one of the big ones. I think another big one that I've seen has been over-reliance on a job description. So typically, we'd like to see employers have job descriptions that clearly identify all the job expectations, the essential job functions. Based on that, they can make a tailored accommodation request. But sometimes what happens is the listed essential functions don't actually match up with what's happening in the workplace. And that gives an opportunity for an employee to, if they're not provided an accommodation based on what's listed in the essential job functions, they might rebut that by saying, well, this is discriminatory because in practice, my job functions don't really reflect what's listed in the job description. So keeping in mind that the realities of the workplace might not mirror what's listed in that in the job description, and then with that in mind, making sure to regularly update the job description so that they do accurately reflect realities of the workplace.
Yeah, those are really good points, Mike. I've definitely seen those issues come up quite regularly, so it's really great to be aware of them. One mistake that I'm seeing a lot, and this is kind of what I'll call the well-intentioned mistake, is the kind of knee-jerk reaction of granting an accommodation request without really evaluating it. And again, this is the well-intentioned, I care about my employee's reaction. So let's say you've got a situation where an employee comes up to their manager or their supervisor and says, hey, listen, I've got a condition, I've got a knee injury, I can't lift over 10 pounds. And the supervisor, well-intentioned, cares about their employees' well-being, wants them to be okay, says, no problem. You don't have to. We can work with that. Just don't lift anything. Everything's going to be fine. And again, that's a really, really well-intentioned reaction, but you can't do that when a request for an accommodation is being made, because in order to make sure that you're doing everything right and you're making the right decision both for the employee and the company, you need to evaluate that request. You need to get the information. Well, okay, how long is this restriction going to last? How does that impact your specific job duties? Is this potentially going to create an undue hardship on the company? Is this going to create a situation where this company would essentially have to assign you to a different job to make it happen? That's why it's so important if, let's say, you're a supervisor and somebody comes to you, even though you want to help them and you want to be helpful and cooperative, to get that request over to someone in human resources or someone who's responsible for evaluating the requests rather than granting them right away, no matter how well-intentioned your thoughts are on that.
Yeah, that's a good point. And I think that knee-jerk reaction can, in and of itself, lend itself to the focal point of litigation. If an employer grants this accommodation without thinking thoroughly as to whether it can, practically be granted, given the job description, et cetera, and then later realizes, oh, we actually can't accommodate this specific request. Again, in the future, the employee can make the argument that, well, you've accommodated it for some time. Why can't you continue accommodating it? And then kind of that could lay the foundation for disability discrimination argument pretty nicely.
Yeah, or another employee may say, hey, listen, you let this other person do this. Why won't you give me that same accommodation? And then you have to start backpedaling, and that's a really difficult process.
Exactly.
So those are all excellent points. What I've seen over the years, and this is part of the employers like templates. They like the same policy is applied to everyone. This is one area where and the courts say it over and over again, it's an individualized inquiry. The facts matter. So if you have, for example, a policy that says 1 year on a leave of absence and you're out, some employers still have that policy. That's a violation because a leave of absence, paid or unpaid, can be a reasonable accommodation. And a court is not going to like the excuse, well, it was a year, so we had to let them go. Here it says right here in our policy, well, you got to modify your policy. It's individualized inquiry. The backdrop, maybe kind of big picture, is we as lawyers never want to be in front of a jury defending a disability discrimination case. They tend to make sympathetic plaintiffs. And you might say, well, California, U.S. has the Americans with Disabilities Act, and California has the Employees with Minor Difficulties Act. And we make light of that. So-and-so's got a bad back. They've had a bad back for the last 5 years. But you really have to approach it as, do we want to be litigating this? Do we want to be fighting in court with a disabled employee who may be very sympathetic? The jury will put themselves in the employee's shoes or in the employer's shoes. So do and say things that you'll be proud of. And that will help to avoid litigation, even at the risk of bending over backwards for this protected class.
Yeah, that's a really good point. I mean, flexibility really is key. And the other area where this comes up, and I'll mention this one last thing, and then maybe we can jump to the next topic, is sometimes employers have, again, well-intentioned and good start. They have a fantastic system in place on how an employee can request an accommodation. This especially comes up in the context where, let's say, an employee enacts a policy where they know there might be some requests for exemptions based on a disability or medical condition, like COVID vaccination policies, for example. So the employer, really nice idea, implements this great system where if you require an accommodation, if you want to make a request for exemption, you can submit a request to so-and-so, then there's going to be a review process. In 10 days, we're going to have a meeting, and we're going to determine whether we can accommodate you. And it's fantastic to have have that process. Where sometimes a problem happens is when you have an employee who doesn't follow that process, and the employer assumes that because they didn't follow the process, they're not entitled to consideration of their accommodation request. And that's just not the case. It doesn't matter how good of a process you have. If an employee goes outside of that process, mentions the need for an accommodation in a completely different way to a supervisor that's in no way responsible for granting accommodation requests, it doesn't matter whether they complied with the process or not. You still have to go through that interactive process with them and determine whether an accommodation can be made.
All right. And I know you said that was the last of this topic, but I have one more just because you mentioned the employer reaching out to a supervisor. Another mistake is not having a policy where an employee is required to reach out to a designated point of contact at the company, whether it be HR or another individual that handles the requests and takes the appropriate next steps. If they reach out to a supervisor or just another coworker, if an employee does that, the request can kind of fall by the wayside and just turn into something pretty bad. So,
Absolutely.
So we're going to move on to the next topic. The next biggest hit that we got from the poll question. The poll questions was best practices for managing employee performance. So I'll jump in on this one as well. Typically, the first thing that I recommend, regardless of, we can start off with evaluations, for example, having clearly identified and specific goals and objectives that you expect employees to have and to meet throughout their employment, and giving those expectations to the employees early on so that they know what their the metrics that they're expected to follow and to meet. Having a conversation with the employees as well about what goals they have and working with the company is really important. I think the biggest issues that I've seen really come into play with respect to counseling and performance improvement plans. I typically try to recommend that counseling comes before any performance improvement plan. Obviously, circumstances can make that difficult depending on what exactly the employee might have done. But performance improvement plans statistically result in a termination. And they usually trigger kind of a warning to employees that signals, oh, I'm going to be terminated. And for purposes of retention, creating a healthy workplace, you really want to have a precursor to that by engaging in a meaningful counseling session where you identify specific issues that the employee is dealing with, giving them an opportunity to respond, and create sort of a dialogue with the employees so that they know that you're working with them to create a solution and so that their work really improves before jumping to a performance improvement plan.
Really good point. And I'll raise another issue that I see sometimes, or in performance evaluations, written reviews, performance improvement plans as well, which is that there's certainly a desire, and an understandable one, by supervisors and anyone who's responsible for filling out these evaluations to be nice, to be diplomatic, to not make employees feel bad about themselves. And again, I'm very sympathetic to that idea. But if you've got a poor performing employee and you subsequently have to terminate them for poor performance, and they turned around and claimed that the termination was because of race, gender, whatever that happens to be, and you say, well, no, it was a performance issue, and those performance issues are not in the performance review, the performance review is glowing and doesn't identify any of the performance problems, you're going to have a problem when it comes to defending and proving the real, legitimate, non-discriminatory reason for the termination. So this becomes really a matter of doing some really good training and coaching for your supervisors who are responsible for doing performance evaluations. Of course, they shouldn't be mean, they shouldn't be rude, they should be encouraging, they should suggest areas of improvement. But if there's performance issues, they need to be identified. You cannot gloss over them for the sake of diplomacy or for the sake of avoiding a difficult conversation.
Yeah, I'll take that last one. I mean, some of the managers, supervisors are friends with the subordinate employees. Maybe they go on a barbecue, they're in a football fantasy league. That's why you need to separate the work from the personal relationships. It's very difficult when you're friends with somebody to have to write down that the employee is not performing up to expectations. So you sometimes have to be candid in those performance reviews and honest. The goal is to improve performance, not to humiliate somebody or make them feel bad. But I see that a lot, what I call grade inflation. So you look at the performance reviews, including the person that just violated every policy in the book, and it says, well, he's a 10, just like everybody else in the group is a 10. So that's a real problem. That means we have to go back and kind of rehabilitate the file and just document. The other thing two other things I would say is be careful about the language used in performance reviews. So, think about it as this is Exhibit A blown up in front of the jury on a huge overhead. And if you say in a performance review, we had to shit can Dave today, that's not going to go over well with the jury. I'm not saying that any of our clients would ever use language like that, but I've heard that sometimes they do. They're upset maybe with the employee. They want to stick it to them. It's not the place to do that, and especially when it's evidence. And that kind of brings me to the last point. I'm a big fan of training, training on discrimination, harassment, avoidance, training on how to be a better manager. So to a lot of us, including the people that are watching, your HR professionals, your in-house counsel, this is common sense. You're telling us stuff we already know, but not to the rank and file, not to the managers, how to do a review. I think that could be, a lot of employers could benefit from training on performance evaluation, how to document everything. And they don't get that. They're not trained how to be better managers, including lawyers. So I think training in this area is really, really important.
Absolutely. And, the other thing I'll note is, and this is, I think you're going to have no two attorneys are going to disagree on this point, but let's say you are going to agree on this point, but let's say you actually get to the point where you're going to terminate for poor performance, right? So the question always comes up when we notify the employee of the termination, when we draft that termination letter, do we state the reason for the termination in the letter? Do we say you are being terminated for poor performance? And the initial reaction, completely understandably so, is to say, well, California is at will employment state, unless your employees are covered by a collective bargaining agreement or some other agreement that says they can only be terminated for cause. You can fire them for no reason or any reason, and you don't have to articulate the reason. So the desire, a completely understandable desire, is to say, I'm not going to articulate a reason. I'm just going to say, that you're not will employee, and we've made the decision for business reasons or whatever else to terminate your employment. You avoid a difficult conversation. You don't have to articulate the reasons. But here's where this becomes risky, at least in my opinion. Let's say this employee then goes and makes a claim that that actually the termination was for some unlawful reason, because they're a whistleblower or because they had a disability. And you come back and say, well, no, it was for performance. And the employee's response is, well, they never told me that. Right? They told me they were terminating me. They gave me no reason for the termination. I asked, they refused to answer. So clearly this whole performance problem thing, they're just making it up now after the fact to justify the termination. And that's a compelling argument for the jury. So from my perspective, it's as much as it makes it more difficult to do so, there's a lot of benefit to, if you're firing someone for poor performance, again, you don't have to be mean or humiliating or demeaning about it, but articulate that reason in the termination decision.
Yeah, I completely agree. I think that's why it's especially important for employers to have a really thorough handbook that really explains policies, expectations, et cetera, because when it comes time, if and when it comes time to termination, I advise having a specific pointed reason that's delineated in the handbook, delineated in the company policies. Because again, the employees on notice, these are the policies, expectations, et cetera. It's much harder for an employee to make the argument that, there's some other pretextual reason when there is, documented evidence in support of the decision, and there's a clearly pointed policy that was violated.
So. Absolutely.
So the documentation is key, though. It's not enough to say Susan was absent from work chronically. Instead, say Susan was late for work 7 times last month, 6 times this month, an hour late or more. Very specific. The more specific, the better. I agree with Olga's point about giving a reason. Sometimes we don't, for strategic reasons. But I will say a termination for performance reasons, a good termination, should never come as a surprise. Should not come as a surprise to the terminated employee, because we've documented it, along the way. There's notes in the performance or the personnel file. There's some warning, maybe a PIP, maybe not, but there's a lot of documents leading up to for performance termination, so that if it's done right, the employee should not be surprised. They have been warned multiple times. It's well documented, and even if they think there's a protectual reason, when they go to talk to a plaintiff's lawyer, they're going to have to be honest and say, well, I was counseled for missing work like 20 days last month.
I notice sometimes, or quite often, is one thing that really gets sometimes conflated is termination for performance as opposed to termination for a violation of company policy, right? And there's really a difference between the two. Performance is kind of an aggregating pattern of not doing your work in a satisfactory manner. Termination for a policy violation is very different. Termination for, coming to work under the influence of alcohol or bullying another employee, that's very different from a performance-based termination, and that's something that doesn't necessarily have that pattern or history. There are certain policy violations that absolutely warrant immediate termination, and that's I would say you don't want to say performance-based. You want to say this was a violation. You're terminated for violation of company policy or terminated for misconduct, because there it's much easier to make the case that it was an appropriate termination, even though, let's say, the employee has a flawless performance history, amazing performer. Doesn't matter how amazing a performer you are, if you harassed or bullied another employee, you're going to get fired. So I think it's important also to really make that distinction.
Yeah, that's a great point and an important distinction, absolutely. I think we'll move on to the next topic, just for the sake of time, so that we can cover our bases here. The next biggest hit that we received in the poll was on wage and hour litigation trends. What kinds of claims are we seeing pursued most frequently in court?
So I'll jump in on that one. And by the way, everyone, just so you know, we're going to cover as many topics as time permits. We probably won't get to all of them, which is why we want to hit the ones that got the most hits and the most votes of interest. But this is obviously a one that I think a lot of people have an interest in. Broadly speaking, we all know what we see in these various wage and hour, PAGA, class action lawsuits. You have the minimum wage, overtime, meal and rest break violations, expense reimbursement, blah, blah, blah. But more specifically, what kind of factual claims and legal claims, plaintiffs' attorneys are glomming onto these days. I'll mention two, and then I'd love to hear from Mike and Tyler what they've seen. The one that we see a lot right now is regular rate of pay violation. Right? That's a really big one that we see all the time. So as you know, if you have to pay an employee overtime or sick pay or a premium for a missed meal and rest break, you have to pay that out at an employee's regular rate of pay. And an employee's regular rate of pay is not just their hourly wage, it's their hourly wage plus any other form of discretionary compensation that they received during that pay period, so that they received a non-discretionary bonus, if they received some kind of shift differential pay for working less desirable shifts, that has to be factored into the regular rate of pay for overtime, sick leave, meal and rest break premiums. And, unfortunately, that's where sometimes you kind of get that unintentional error where their automatic assumption is that it's just an hour and a half of their hourly rate, right? And plaintiffs' attorneys kind of love that one because that one's really easy to prove, and it's really easy to make a class action out of a claim like that. Because if you've got an employer who consistently pays out overtime at just the hourly rate, that's a class-wide issue. And it's very easy to kind of pursue that as a class issue. So that's one that we're seeing a lot. And then I'll mention one more, which is, I think it's a little bit too broad to say, off the clock work. You're always going to get claims of off the clock work. The one that I'm seeing a lot lately is the claim that because I'm expected to be at my workstation ready to start working right at the beginning of my shift, then that necessarily means that I have to, before clocking in for my shift, to do certain things to get myself ready, put on my protective gear, go get my tools from another room, things like that. So that's what I'm seeing a lot as well, which is why it's really important when you're kind of regulating an employee's schedule and even drafting like attendance policies and timeliness policies. You have to make sure that you're conscious of the specific nature of your business and that you build in time so that if the employee does have to do donning and doffing or go grab their tools, even if it takes like 15 seconds, there's no de minimis doctrine in California. You have to pay for every second, essentially, that you build in an opportunity for employees to do that after the clock rings, after they clock in for their shift.
Right. And that situation comes up in instances where you wouldn't originally think, in particular with respect to employees who are working remotely or working in an office using their computer for all of their job duties. Computer startup time, as we know from cases that came out, I believe, at the end of 2022, very clearly indicated that, that time, startup time for, folks using computers at work, that's compensable time, and that needs to be accounted for when calculating at what point a meal period should start, at what point rest periods should be provided for overtime purposes. For all those considerations have to be thought about when folks are using their computers to work as well.
I would just add from my perspective, it used to be some time ago, early in my career, nobody cared about meal and rest. It was never a claim. It became a claim, after they filed the misclassification cases. People were actually not managers entitled to overtime. That was the first wave, and then we got the meal and rest. We have the Brinker decision, which held that as employers, we're not required to be the meal period police, or rest period police. We don't have to look over their shoulders. But to kind of reduce this to stark reality, when I show up at mediation trying to settle a putative class PAGA action, the first thing I hear typically is they'll go through the sample of records and how many times did an employee have a shortened meal period, so less than 30 minutes, uninterrupted? How many times did they miss a meal period or take it late? So it's got to be taken in the first 5 hours. So they will look for those. They'll look for violations. They'll extrapolate to the class and say, based on this 10% sampling, and you do the math, and now we got a $5 million settlement demand. And how do employers deal with it? I'm going to ask Olga too, because I know she does a lot of wage and hour. It's not enough to just have a policy in place. You're not the meal period police. You need to enforce the policy. If employees are out there and they're like, yeah, I don't want to clock out. I don't like Big Brother telling me to clock out. I'd rather stay on the clock because I can make more money. Mm-hmm. They need to be disciplined. And if it persists, you need to terminate them, because in a class action lawsuit, that's very powerful evidence that not only do we have a compliant policy, it's 100% up to snuff in California law, we also enforce it. And if somebody deviates, you're not willing to follow, get with the program, then we're going to have to let you go. Because the explanation or when they say, well, you can't tell me, I want to do my own thing. It's California law. It's not the big bad employer. Everybody can see in LA Times, San Francisco Chronicle, the headlines, what these cases go for, millions and millions of dollars just over meal and rest. You need to be proactive and build in a defense.
The kind of sad part about it is this whole decision in Brinker, the fact that employers don't have to police meal and rest breaks. The intention behind the decision was good. It was meant to benefit both the employer and the employee, right? Because it benefits the employer because the employer doesn't have to police its employees. It benefits the employee because the whole idea is because the only thing that an employer needs to do is make a meal break available, the employee can choose. Let's say they want to leave early that day because there's a sport event at their kid's school. They can choose to not take their break so they can leave early. That was the intention behind it, but the problem is that the popularity of meal and rest break claims kind of ruined the purpose of the case, because the problem is now is if you tell the employee, well, you don't have to take your break, we're going to make it available, you absolutely should take it if you want to, but you don't have to, and employees don't take them voluntarily. The problem is a year later when that employer gets terminated for poor performance or violation of a company policy and comes back and says, well, no, I didn't miss those breaks voluntarily, right? I was forced to miss them, or I wasn't given an opportunity to take them. How do you disprove that, right? So unfortunately, the fact that these meal breaks and rest break claims are so popular kind of deprives both the employers and employees of the opportunity to have this kind of grown-up, mature arrangement where employers make the breaks available and employees can choose whether to take them or not. It's just too dangerous.
Yeah, it's what I call the no good deed goes unpunished phenomenon.
Right. And sometimes I know employers have thought about the pricing issues with having really up-to-date technologies to monitor clock in, clock out times, et cetera. And that obviously creates a little bit of a financial burden. But the financial burden on the other end of a lawsuit is much greater. So investing in those types of technologies and being diligent about monitoring clock in, clock out times is cost saving in the long run. Timekeeping. Yeah.
Seems like a good segue, right?
Yeah, I think so. So one of the next biggest hit that we got was on timekeeping for non-exempt employees, best practices and common mistakes.
So Tyler, other than making your employees take meal breaks, what would you kind of best tough tips on how to get this right on timekeeping?
Yeah, so I like the electronic timekeeping. I like the mobile app on their phone where the employee is responsible, but you have to enforce that, and so they like the freedom of doing that. You can clock out, you're on the 405, you need to pull over, clock out for lunch. The problem is when they forget to do it and they're not doing it religiously. I like the electronic because it's hard to argue with. And Olga and I have dealt with manual time cards, and that can be very, very challenging. Just to get the data can be very challenging. So I do like electronic. It could be a badge, could be like a mobile app on the phone if they're remote. But the enforcement is really what I'm seeing is where employers fall down.
Yeah, and the electronic timekeeping capabilities are a blessing and a curse, right? They're a blessing in the sense that it does make it a lot easier to track employees' time. But the fact that it's now so easy, quote unquote, because of electronic timekeeping capabilities means that courts are going to be a lot harsher and stricter on employers to get things right. That's one of the reasons why California courts decided that rounding is impermissible. What you'll see in these decisions about rounding is, listen, employers have these great available options for electronic timekeeping. Technology has advanced so far that it shouldn't be difficult for employers to track their employees' time down to the minute. And given how much easier it is to do that now than it was when we were just dealing with paper time cards, there's really no excuse for rounding.
Right. And, I think Tyler mentioned this earlier, but there are instances where an employee simply forgets to use the timekeeping system, forgets to clock in or clock out. Designating a point of contact, whether it be a supervisor or somebody else that is monitoring these clock in, clock out times and ensuring that folks that they supervise are being diligent about using the software appropriately and on a daily basis. And of course, if there are instances where an employee didn't take a meal break, obviously providing the meal break premium payment for the missed meal break or the short meal period. But if that's not happening, it's going to be incumbent on the company, and specifically can be assigned to supervisors to check in, make sure that the employees are actually using the apps and using whatever system is being applied.
Right, and with the apps, now here's an interesting question. Let's say you have your employees clocking in using an app on their cell phone. Does that mean you now have to compensate them for work-related use of their personal cell phones, Tyler?
On this area, I say err on the side of caution and conservative. Like the rounding, the donning and doffing, the showing up and logging in, pay for it. Don't leave it to chance and to litigation.
And if that's the only reason for which your employees are using their personal cell phones, the kind of the monthly stipend that you pay out for that could potentially be smaller than in a situation where, for example, your employees are regularly making work-related calls on their cell phones. But that's just a little potential trigger if you're having your employees use these timekeeping apps on their phones.
Yeah, that's a good point. I think while we're on the topic of wage and hour issues, I think we'll move on to one of the next biggest hits that we got in the poll, which is classifying employees as salaried exempt, most common mistakes resulting in misclassification.
What are the ones that you've seen happen?
So, the biggest thing is just the duties don't match either. We have they call it the executive exemption, manager's exemption. In California, it's not as favorable to employers as the federal test. Under the FLSA, they use is your primary duty management. Just make it a little more concrete. If you're a manager at McDonald's under federal law, clearly you're exempt. Your primary duty is managing employees, setting schedules. Under California law, you go to a labor commissioner hearing, the labor commissioner hearing officer will actually say, well, how much of your time was spent making hamburgers and manning the cash register and doing other things that are not management tasks, and they'll add them up. Well, only 48% of your time was on traditional management duties. You're non-exempt. You're non-exempt. You're entitled to overtime. So that's still a big one. I think people don't understand the duties on some of the other ones, like the administrative exemption, the professional exemption, which is tied to licensure or education. And then, deductions from salary. So a salaried exempt employee is paid not on the quantity or the quality even of their work. It's a fixed predetermined amount. So if somebody leaves for a half a day and you deduct from the salary, that might not be a great example, but you deduct like 2 hours here and 2 hours there, you've then violated the salary basis rule. You've converted that person into non-exempt, even if it's the CEO of the company, with obviously falls under that executive exemption. If you're making those deductions from a predetermined fixed salary, you've now converted that person potentially into non-exempt. You violated the salary basis rule.
Yeah, and the whole having to spend more than 50% of your time on exempt tasks, that really becomes an issue sometimes. The question arises, for example, and we've had cases like this in California, and I think you can guess how they came out. So let's say you've got a manager in a grocery store, and so the manager is stocking shelves while at the same time supervising the other employees. Does that time count towards exempt tasks or non-exempt tasks? Well, surprise, surprise, it counts as non-exempt tasks. So, to any extent that there's a massive presumption in favor of employees being non-exempt. That's always going to be the presumption, that an employee is hourly non-exempt and is entitled to minimum wage and overtime and meal and rest breaks. So anything that's even slightly skews in favor of non-exempt classification, it's going to lean in that direction.
Right. And another issue I've seen is where people incorrectly use the term salary or salaried and exempt as synonymous, but those two things are not the same. Being exempt obviously requires having a designated job duties that are delineated in the labor code and in California law. And some employers will pay an employee a salary, and even if it's above twice the minimum wage as required under California law, that doesn't automatically transform them into an exempt employee. So really being mindful of what the job duties are, how much it could be an independent judgment that the employee is using when performing their job, things like that. Just keeping in mind that those two things are not the same, because that'll get employers into some trouble as well.
Absolutely.
That kind of reminds me of the debate about independent contractors. And, it's not enough to put a label on somebody that they're an independent contractor. It's the actual economic realities. What are they doing? And just sticking with independent contractor, California law, for a long time, we complained as management lawyers, our clients just want to comply with the law. We want bright line rules. We want clear rules. None of this gray stuff, is a person more like a carpenter or more like a assembly line worker, or somewhere in between. Just tell us. So the California Supreme Court and the legislature, I guess, did us a favor by saying, after Dynamex and the AB5, the new law, the new rule is, like bright line rules, you cannot have independent contractors anymore in California unless it's really a bona fide carpenter, multiple customers, their own insurance, their own business. I give you another real world example. Law firms, we have e-discovery, right? Well, one of the B prong of the ABC test is, does the putative independent contractor do the same work that the employees do? Well, if the law firm has an in-house e-discovery and we hire a vendor that might have 100 employees doing e-discovery, there's a chance they could be employees, right, under ABC. So it's just become very, very challenging. And the lesson is, it's not enough to slap a label on somebody. You're salaried exempt. You have to look at the duties, the job description. Independent judgment and discretion is always a debate. Because if you're just doing route stuff, following a manual, you're not going to be exempt, no matter how much you're paid.
Absolutely. Yeah, so labels, that's true. Labels really don't go very far, but even the labels themselves can create a risky situation when it comes to classifying someone as salaried exempt. This might actually be a good transition into the other topic that people are interested in, which is offer letters and employment agreements. What are the must-have provisions that are really important? I'll maybe can start with that discussion with a provision that I would be very careful about not including when you're doing an offer letter for a salaried exempt employee, because I'll see offer letters to salaried exempt employees sometimes, and they'll say, this is a full-time position and your work hours are 9 to 5. Well, and that automatically sets off a bunch of red flags for me, because it's not necessary. It's clear to me, based on the fact that this is a CEO or a vice president of marketing, that the intention behind that provision isn't to say that you're going to be compensated based on the number of hours you work. It's just standard language that everyone feels okay including in any type of offer letter. But even using those words, full-time, work hours, risks compromising the salaried exempt status of that employee, because it creates the impression that that employee is expected to work a certain number of hours. Now, remember, there's a big distinction between saying you have to work from 9 to 5, you have to work 8 hours, and your job duties require you to be available from 9 to 5, because that's when you're going to be doing your work and you need to be available to our customers during that time and to other employees. That latter piece is perfectly acceptable and perfectly fine for exempt employees, but you have to be very careful when you're phrasing that contract language or that offer letter language to not make it sound like there's an expectation that the employee has to work a certain number of hours.
All fair points, Mike.
Yeah, I mean, I think the other, the big one that we usually include in any sort of offer letter or employment agreement is identifying that the employment is at will. Obviously, it usually goes without saying, but I've run into situations where if that wasn't clearly stated in the offer letter and there results in termination, there could be an instance where the employer tries to fight back as if there was some quasi-agreement guaranteeing their employment with the company. Obviously, again, that's not the case, but it can create these hurdles that employers have to fight.
And depending on the level of the employee, we may have an attached proprietary information convention assignment agreement. We may have an arbitration agreement. That's a whole nother debate about whether arbitration is worth it or not. Can you enforce those? But you want what I call the onboarding package. It's not just the offer letter. I like to have them sign the handbook acknowledging they've received it, they've agreed to read and understand it. Arbitration agreement, PIIA, stock agreement. If there's a stock agreement, you want to spell that out. If there's options, if there's a vesting period, that all needs to be vetted and carefully drafted. I think in this area, there's a tendency to just dupe and revise. And we talked about templates before, and you really have to take that, an HR or the manager, take that extra step to make sure that what you drafted for Joe 3 years ago still applies, both the law and the position, tailored to the individual.
The one provision that I tend to be very, very careful in the way I draft it in offer letters and employment agreements is kind of the conflict of interest provision, right? Because I think it's actually really important to have a provision in there that says that I'm not going to engage in any outside activity, other employment, other work that conflicts or interferes with my duties to my new employer. That's, I think, absolutely should be in there, and it's very important. But where you hit a little bit of a risk area, or maybe potentially a lot of a risk area, is where the employer goes a step farther and essentially includes like no moonlighting provision. And it usually says something like you're expected to devote your full time and efforts to the work at this company, no outside employment, all of your, again, the intention usually behind this kind of provision is just to make sure that they're not going to get distracted by running a side business and have that result in them not doing their job. But the problem is that if you phrase a provision like that really broadly, no moonlighting at all, there's a risk under California law, because under California law, an employer cannot interfere with an employee's lawful off-duty conduct. they cannot prohibit they can't control what employees do off duty outside of work as long as that conduct is lawful. So if you tell an employee that you can't moonlight, you can't have any other jobs, even if those other jobs are completely different, you're a computer programmer here, and then in the evening you want to go and work at the McDonald's drive-through window a couple of nights a week just to make a little extra money, and you're telling an employee they can't do that, even though there's clearly no competitive conflict, there's no conflict of interest, the employee's quality of performance for you isn't going to be impacted, then you risk actually being sued for a violation of privacy, because that's the claim under California law if you try to prohibit or interfere with an employee's lawful off-duty conduct. So I think you absolutely need to have a conflict of interest provision in an offer letter and employment agreement. I also like to include in there, even though it's also going to be in the PIA most likely, a provision saying that you're not bringing over any of your former employer's stuff. You're not going to use it. You're not going to violate any obligations to your former employer through the type of work you do for us. You just have to be careful not to have that provision be so overbroad that you're accused of interfering with lawful off-duty conduct.
That provision that Olga mentioned, by the way, is in the Labor Code, 98, I think subdivision K, if I'm not mistaken. But that's in addition to the invasion of privacy claim. The Labor Commissioner has jurisdiction over a claim that the employer either discriminated against me or retaliated against me for, quote, lawful off-duty activity.
Mm-hmm.
I think we have time for one more topic. I think we'll jump into one of the next hits that we got was on tips and best practices for implementing diversity, equity, and inclusion policies in the workplace and initiatives. So as a precursor, I'll jump in and talk about this first. As a precursor, I think a lot of employers may have been spooked. Earlier this year, the Supreme Court decision in the SFFA, the Harvard and UNC cases, issued its decision on affirmative action applicable to public universities. And I believe there were 13 state attorney generals after the decision was released that, released a statement to private employers in their own states saying, kind of identifying the legal risk of focusing on race as a deciding factor when employing somebody. And that's, it kind of convolutes what the opinion was actually about. Employers aren't allowed to do that anyways under Title VII and the FEHA. Identifying and focusing on using race as the reason to hire somebody is, it's been illegal for a long time. So it kind of convolutes what the opinion is actually about and what the law is. And it's important to remember that having a DE&I program is still completely lawful and, oftentimes encouraged. And the focal point is about fostering an inclusive workplace, as opposed to having some sort of racial quota or other identity quota. We strongly recommend against that, because that can violate the FEHA and Title VII. So some of the tips and best practices that I would recommend include, focusing on removing barriers in hiring practices. So when you're hiring and recruiting, going to different, diverse places to recruit, and again, not focusing on the quota itself, but looking at opening up the opportunity for employment to all types of people. Another big part of having a DEI initiative is, creating and establishing DE&I policies that have clearly stated initiatives and goals. And again, the goals should be clear that it's focusing on fostering a healthy workplace as opposed to meeting some sort of quota. Something that our firm does that I think is really great is focusing on creating employee resource groups, or ERGs. And I know Tyler and I believe Katarina Cologne, another associate in our Milwaukee office, drafted a really good article on this point. What ERGs are, again, they're really focused on creating community for folks in the firm, having just a space for employees to connect with one another, as opposed to an affinity group, which is more about having a social purpose. So, of course, you can reach out to us to talk about ERGs and DEI initiatives as well. We have a workplace DEI subgroup at the firm. So.
And I would just add to that for the quick little bit of time we have left is, I think, in terms of implementing an inclusive workplace and ensuring that it remains inclusive, training is hugely important, right? Because we've been doing these for the past couple of years. We've been doing a lot of implicit bias training. right? Recognizing the notion, especially for people who are involved in hiring decisions, recognizing the notion that implicit bias, it is a scientifically proven human tendency, right? Because your brain can only take in so many pieces of information. And as a result of that, it's susceptible to stereotypes. And it's also susceptible to this kind of similar to me phenomenon where you tend to gravitate more towards people who are like you in whatever way, whether it's someone similar to you in race or in the clothes that they're wearing or the school they went to. Training people with decision-making authority on recognizing implicit bias and make sure it doesn't make its way into hiring decisions, promotion decisions, any kind of work-related decisions. I think that's an ongoing practice that employers should continue to do. And I think that's also going to go a long way towards employers' goals to have an inclusive, diverse workplace.
Yeah, absolutely. And that's a hard task. I think it's important to hire properly qualified individuals to conduct those trainings. It's not something that any, one of us can do unless we've had that type of training ourselves.
Absolutely.
Yeah, I would just add, the mentoring is really important. Like, it's great to recruit diverse candidates, but to also support them. That's why I like the ERGs. I had great mentors, as a progress in my career, and that's hugely important. And it's somebody that they can identify with. They can have lunch occasionally, be kind of somebody to lean on is hugely important to increase diversity and DEI efforts.
I've had great mentors too.
So thank you all for attending. Just as some closing thoughts. First of all, thank you all for attending, the thousands out there in the audience, the live audience here in front of us and also online. We hope the information was helpful to you. As I said at the outset and during, if you have questions about any of the topics, feel free to reach out to us. Even if your questions are purely hypothetical, we want to answer all of those situations. As a reminder, the program has been approved for continuing legal education credits. So to report your hours, click on the CEU icon. It's hard to say for me. At the bottom of the screen, a certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. That's a little bit scary. And be sure to complete the last thing. Be sure to complete the short survey. Again, we use your feedback to try to improve this every time, and next year it's going to be bigger and better. So with that concludes our webinar today. Thank you again, Olga, Mike, Allison, for attending, and all the people behind the scenes. We have an army here. Thank you all for helping us put this on. Thank you.